It's all good. Alrighty, Mr. Chairman, for House Education, January 24th, 2025, Representative Bratton,
Here.
Representative Erickson,
Excused.
Representative Guggenmoss,
Excused.
Representative Kelly,
Here.
Representative Lawley,
Here.
Representative Singh,
Excused.
Representative Strock,
Here.
Representative Williams,
Here.
Chairman Andrew.
Here.
You have a quorum.
All right, thank you and welcome. We're going to do things slightly differently today in order to take as much public testimony as possible. We just have two bills to work, but we're going to move them both separately before taking public comment, and we'll discuss them as a committee, and then we will move on and use the rest of our time for public comment and work them after that. So House Bill 60 is now on the table for consideration, and Vice Chair Lawley will explain the bill. And Vice Chair Lawley, who would you like to? I think there's someone you'd like to bring up.
We're doing 60.
Oh, all right, please go ahead.
Thank you, Mr. Chairman. Rest of the Education Committee, good afternoon. It's my pleasure to present to you House Bill 60, Student Eligibility in Sports Amendments, and ask for your favorable consideration. This is an amendment to the sports bill we passed 2 years ago. I would like to just note that that bill has gone unchallenged and has been a success in the state of Wyoming. This is going to amend the sports bill to include collegiate sports. It's also, the bill will update some definitions, and you're going to see some consistency in the definitions from what was in What is a Woman Act that the House has already passed in this bill and in the next bill, House Bill 72, to bring some kind of consistency and alignment of definitions in this area of our position in gender issues. So we do update those definitions. We also bring the bill back to its original form when the sports bill was done 2 years ago, that was K through 12. It was amended on the floor of the House to, I think, 7 through 12, excuse me. And so we're going to bring that. So that's really what the bill does. It takes that existing sports bill that we passed that's gone unchallenged, and it creates, it adds collegiate sports, which would be not only the University of Wyoming, but all of our community college. And all the same things that I argued on the floor for the original sports bill are still in play here. The issues of fairness and equity and safety, and that's what we're addressing. For many of you who may not know, over 50 years ago, we passed something we refer to as Title IX as part of the Civil Rights Act. And Title IX said that women would have their opportunities in sports. In effect, at that time, and I was in high school when Title IX was passed, so I have great memories of this, it basically said women have a right to participate in sports against one another, and that schools, if they offer sports for boys, would need to offer sports for girls. That was life-changing for many, many girls in my high school. I wasn't one of them because I'm not athletic at all. But for them, it offered scholarships, opportunities, and just an amazing high school experience in participating in girls' sports. So I have an affinity to Title IX. I still believe Title IX is the correct law, and it is written in very, very objective terms. And we now live in a society of a more subjective view in the area of gender. Some have a more subjective view. So that's why we're speaking into this. And the essence of this bill, as it concerns the University of Wyoming and adding them, is because that for these reasons of fairness, equity, and safety, we must protect women's collegiate sports. We had a situation at the University of Wyoming with the women's volleyball team. You'll hear more about that today. And it really opened our eyes to the need. We had hoped the NCAA would do something and deal with this issue. That's why they weren't included in the original sports bill. But that hasn't happened. And when I was going door to door during my campaign, I heard about this and the next bill more than I heard about property taxes. And not that people weren't concerned about property taxes, but I would often hear, you must get boys out of girls' sports and the boys out of the girls' restrooms. This is common sense to the people of Wyoming for the most part. They're not wanting to necessarily unfairly disadvantage anyone. That is not the goal of this. It is to speak to this issue of what Title IX spoke to, a women-only lane, women-only spaces, and the importance of preserving that. And so in adding University of Wyoming to the sports bill and the community colleges, we simply want to preserve the Title IX lane. I'll also make this observation. One of the first executive orders that President Trump signed related to these gender issues. And it was very interesting to me. I looked Monday night and trying to find the wording of the executive order. I had seen press on it, kind of summarizing it. But I did track it down. And basically, what we're doing in these two bills today aligns with what the federal policy will be at the federal level. We're talking about what we're going to do as the state of Wyoming, which is our decision to make as a state, and the legislature is the place that we speak into that. So I just point that out because we have a new administration. There's going to be a lot of things changing in this area, but what were signaled in that executive order is that we are lining up with them in terms of definitions that are biologically based, the idea that we're going to use objective standards, not subjective standards, and that this idea should run across the whole of government. And so you're going to see that as we move through these two bills. But as to this bill, I will just say that this bill in no way prevents collegiate sports from creating other opportunities for transgender players. It simply doesn't. There's freedom. There's all kinds of options that are open for these collegiate sports world to create some of those type of opportunities. We're just simply talking about the Title IX lane for women will remain for women only. And with that, Mr. Chairman, I will stand for questions from the committee.
Thank you, Vice Chair Lawley. Are there any questions for the sponsor? Seeing none, we will now take a break on that one and move on to the other one, which the number is House Bill 72 is now on the table for our consideration. Vice Chair Lawley. And
Yes, I forgot to do that, didn't I? I'll do it at the end of this and they can both come in maybe.
okay.
Okay,
Which two?
Erica and Sarah back. Thank you, Mr. Chairman. Members of the House Education Committee. House Bill 72 is protecting women's privacy in public spaces, and I ask for your favorable consideration. House Bill 72 ensures that women and girls are safe and respected in places where privacy is essential. Bathrooms, locker rooms, showers, changing rooms, overnight accommodations, and correctional facilities. The bill provides clarity and creates consistent policies that prioritize privacy and safety in public schools, higher education institutions, and correctional facilities, and really all state public buildings. House Bill 72 sets a clear standard that men cannot access women's intimate spaces like showers, restrooms, and housing facilities. It gives women a way to hold institutions accountable when those protections are violated. And these are really important things. If we're going to speak into this issue, I believe we must speak into it with clarity and certainty, with common sense approaches, and we must give relief for those when these protections are violated. 12 other states have enacted women's privacy protections. Many other states are considering bills even this year. House Bill 72 sets clear standard that men cannot access these women's spaces. It also, as I said, gives women that right to protections if the law is violated. we live in a very different world than when I grew up, and a different world than I would have expected even 10 years ago. But this is where we are, and it calls for some clarity. And unfortunately, under the law in Wyoming, men who assert a female identity are allowed to enter private restrooms, showers, changing areas. We have documented incidents of this. You'll hear about some of those today in generalities, but here in Wyoming. One of the reasons I wanted to run this bill and started working on it in August after the primaries were over was not only had I heard a lot about it at the doors, but I had school board members coming to me and saying, we need the help of the legislature. We are paralyzed in terms of what to do, and we need some guidelines. We need some guidance on what the policies should be. So that's one of the reasons I'm bringing this bill. As I mentioned, President Trump's executive order that was issued on Monday aligns with this bill in many ways. Not so much in the specifics as we go through it, but in the policy in general about we will have clear standards, and we will hold folks accountable that won't follow those standards. And the idea that these definitions are important to bring clarity when there are times of dispute. If there's not disputes, well, a lot of things will continue to work the way they have been. When people get employed, they say, here's my information, this is my sex, and we go by the documents like driver's license and things we're currently using until there's reason to have a different understanding of the facts. Partly because documents we relied on 10 years ago, even 5 years ago, as being unchangeable are no longer so. In many states, you can have you designate a different sex on your driver's license if you so choose. Same with birth certificates in many states. Some even will allow you to backdate them to birth. So we will use these documents, but we do understand that they may have some fallibility in terms of what our definitions of male and female are. One way I want you to think about it, because I think this has stumped a lot of people, these definitions themselves are not a test. They're simply definitions that would be used by anyone who would have to arbitrate what's really happening and what the facts are. So whether that's someone at the school district level or someone in a building, or if it's a court of law, this is how they would arbitrate that. But it's not a test to get in a restroom. That's not really the way it's designed. And think of it this way. So we're here in the Capitol, and there are signs, for example, up on the House level that say legislators only and legislative staff only. Usually they say both legislative staff or legislators only. So if I go into that door, they know I'm a legislator. Usually I've got my name tag on if they don't recognize me, and I go into the door unquestioned. But if someone enters that they don't know, or that meet that criteria of a legislature or the legislative staff, then they would stop naturally in any office building and ask them, are you staff? Are you an employee? Or questions like that. So it kind of is similar to that. If someone who walks into a restroom that doesn't look like they belong in that restroom, then someone is going to ask if they are a male or a female. So I just want you to have some working knowledge of how this is going to work, because I think it's been by some folks a little bit misinterpreted. And so I believe basically that women and girls deserve to have their privacy and dignity safeguarded at school, and they also need to have the right to privacy and safety in other safe spaces and what I would call really intimate spaces that are mentioned in the bill. And I guess here's the really bottom line for me. That right to privacy should not be threatened by or trumped by someone else's view about gender. And that's really kind of what the bill seeks to do, is to arbitrate that and say this is going to be the priority, the privacy and safety. So, Mr. Chairman, I would be happy to walk through the bill if you like, or we can, the committee can let me know what their pleasure is. concerning the bill, I would do that, and I do have an amendment, small amendment.
All right, if you'd like to walk through the bill and explain the amendment as well at this time, does anybody have any questions for the vice chair before she gets started with that? Do you have anything you want your people hoping to
Yes,
explain to
yes.
say?
Yes, I would, Mr. Chairman, thank you. I would like to, if it suits the chairman, to include some folks that I worked with in writing each of these bills that will help us perhaps if there's some questions about some of the language. I think I can answer a lot of it, but I'd like them to be available, especially if there's additional questions later.
All right, could you please let Eric, Miss Nolan, and Steinmiller down? Yes,
Mr.
I'm
Chairman?
sorry about the name, but yes, please, those two. And they to be available for questions on the bill. But I'd ask that if they are going to give personal statements of testimony, that they do that during public testimony.
Mr. Chairman, they have joined us in the room, so they are available whenever you have questions for them.
Thank you.
All right, thank you, Ashley. Vice Chair Lally.
Thank you, Mr. Chairman. I will kind of go through the bill. I know you guys have read it, and we've had some discussions, some of us with your questions, and I appreciate those. But the bill, first of all, where the bill is placed in statute, I think is kind of important to understand how I approached it and how seriously I was about the idea that we need to have understanding that there will be protection. So this bill is actually put kind of in the governmental, governmental in these parts of the statute where we are really going to talk about this is the duty of government to take on the understanding, the policy, and ultimately the enforcement of these policies in the public space. And so with that said, we have a lot of definitions in this bill. This is an area that definitions are very important, in part because there's a lot of at least implied policy in some of the definitions. And we've, again, brought them to give clarity to a situation that's become fairly unclear. I'll just point out definitions. I would, there's the educational facility, correctional facility. This, we do cover women's prisons, and we'll talk about that later. Then we really, the definitions of male and female, again, are consistent with the ones we're putting in other statutes, in a bill here, and then in both of the bills we're talking about today. And then there's definitions that are about places, like that these private places. So we have definitions of restroom, we have definition of what sleeping quarters are, and so that everyone can know what we're talking about. Sleeping quarters relates to overnight trips that people take from school primarily. That's what it was talking about. It's like when you go on a band trip, or you take a trip with the choir, or whatever activities that many of our schools enjoy. So the idea of these sleeping quarters is a temporary sleeping quarters. We have another place in the statute that we talk specifically about dorm rooms, which is different. Student housing is different than the sleeping quarters. Just want to clarify that as we go through, there's a distinction there. Maybe not so much in the outcome, but in where you find it and what it's doing. So again, what we have is we deal first with public facilities in the first part of the statute. And then the second part addresses education uniquely and specifically. Why did we do it that way? Well, partly because there are some nuances in the education field that we felt needed to be dealt with. You'll see some differences in statute of limitations, for example. The cause of action in just a public space that's not educational space is 2 years. In the education space, the statute of limitation is 4 years, because sometimes children don't talk about things right away. And so we gave a little bit of leeway if there was something that maybe happened in a restroom that a child did not report right away, which is we do that sometimes when we involve children, we do that. So we put them then in separate parts of the statute. So again, we start with, I want to introduce you to this idea too, which is multi-use versus single use. Because the statute uses this term a lot, because there are times when what we're talking about here is what happens in multi-use restrooms. Where you see single use, it's an example generally of an accommodation. One of the best accommodation is going to be, for someone, is going to be a single-use bathroom. And that is an accommodation. What's not an accommodation is to have someone use the restroom that isn't their sex at birth, their biological sex, so as defined in the statute. So again, with that in mind, Mr. Chairman, I would just say that we define that, as I said earlier, that boys use boys' restrooms, girls use girls' restrooms, sleeping quarters, changing rooms, locker rooms, and all these things, that the policy goes all the way through and even through our prison system. And so there are some unique situations that are addressed as far as employees being able to come in and perform their normal duties as long as no one's there, or we have an amendment that addresses also something that not just coaches, but situations like coaching where you have a coach of a different sex than the team, and some policy about what you do. One of the things I wanted to do in this bill was to address the issues for schools with policy. Here's what you do in this situation or that. So we create different causes of action, as I referred to earlier, and there are conditions on those we specifically describe. So most of them have these two elements to them. That the public facility or the educational institution provided the other person permission to use the changing room or rest area of the opposite sex. So permission was actually given by the public facility, or you're going to see the same language in the educational space, or they failed to take reasonable steps to prohibit the other person from using the changing area of the opposite sex. So this idea that someone said, hey, this person is using the wrong restroom, and they failed to actually address that issue. Those are the basis of the damages. It's not just, something happened, an accident, or there was some unclarity there, but those are the elements of a cause of action that can be brought. There's provisions for damages. We have, in the educational space, we have a provision for also injunctive relief, which I think is really important, especially there. But injunctive relief and also what's called declaratory relief, which means a quick determination by the court, declaration of what's happening. And the injunction is the instructions to stop or to enforce the policy. And we also have additionally damages in the school space. So there's exceptions on every area. There's exceptions, and they're common sense exceptions that are easy to understand and to follow. So while we're saying the policy is clear and it's pretty basic, we understand there are many situations, for example, emergencies that can happen. There is a ability for someone with a disability to choose or assign someone to come into the restroom with them, but they have to be of the same sex. So, but again, there's also the single-use option. So I'm trying to, a few things that people have raised with me to kind of address those. We have, some language in there to try to address these situations to provide clarity. I'm not saying that we covered every possibility, but in the end, I think what this bill does is it provides the direction and the policy for each of those that are expected to enforce the policy. And again, Mr. Chairman, I would just ask if the committee has any specific questions concerning the bill. I can go over some of those provisions more specifically.
Representative Singh.
Thank you, Mr. Chairman, and Representative Lawley. I do have a concern about the bill. How would this bill accommodate traveling sports teams that they may, in after-school hours, that the opposing team would want to have their team in it would be designated to the opposite sex, but under, current practice, they would go into that locker room.
Vice Chair Lawley.
Thank you, Mr. Chairman. Thank you, Representative Singh. We actually have a provision in the bill about that they can kind of temporarily designate the girls' locker room for a boys' locker room. And again, no male or no females in there, but they would operate under the same provisions as the other boys' locker room. So there are situations where they can make temporary assignments.
Further questions? Seeing none. Oh, Vice Chair Lawley, please explain the amendment.
Thank you, Mr. Chairman. I think all of the committee has a copy of this amendment. And this is very much clarify some unique situations that could happen and give the school some leeway, but kind of give a guidance on it. So on page 11, after line 18, we would insert the following, Romanet number 8. A school official or employee who enters the changing area, restroom, or sleeping quarters while in the performance of the officials or employees' official duties, and who takes reasonable steps to ensure that no person in the room is in a state of undress. If I could just explain. So let's say that you had and this can happen, that you have a women who are coaching a male team or a male that's coaching a female team in high school. This would address the fact that they could at some point come in the locker room when everyone's dressed and give final instructions or somehow address the team, especially if there's no other place for that. So it's really trying, but it could be even other situations. We looked at maybe coaches, but wanting to not be so prescriptive about it, because there are a lot of different situations like that where there might be a need to do that. So that's why for any employee in performance of their official duties, enters where there's changing or a bathroom, a locker room, any of those, they would have to first, I think it says, take reasonable steps to ensure that no person in the room is in a state of undress. So that's what that's for. I think it helps those situations a little bit. The bill really, in my view, already kind of said that, but I think this does help to address that issue, Mr. Chairman. So I would move this amendment to House Bill 72. That's right. That's right.
All right, are there any questions on this amendment? All right, seeing none, would the Department of Education like to provide comment on either of these bills, 60 and 72?
Thank you, Mr. Chairman, members of the committee, Megan Degenfelder, State Superintendent of Public Instruction, here to offer support of both bills. I appreciate the bringer's work on this. This has not been an easy lift. And so I'm appreciative of all of the work that's gone into both of the bills. As the bringer mentioned, this is really about safety and opportunity in women's sports, upholding Title IX. There are many ways that we can honor the achievements and the rights for our transgender students, but this is not the place when we're talking about sports and bathrooms. And so I think that's an important piece to remember. As many of you know, we've been fighting hard at the federal level on this issue, and we're actively involved in the passage of the previous iteration of the bill. And so I won't spend a lot of time on that and what I've spoken in terms of those efforts. But what I will share is another hat that I wear is as the coach of the University of Wyoming women's rugby team. It is a Division I club sport. It is arguably the most contact sport that exists. It is full tackle with no pads whatsoever. And my number one priority as their coach is to protect my girls. And when we're talking about something as contact and intensive as rugby, I take that very seriously. It's not uncommon for a collarbone to be broken. One of our players broke their back. Injuries to the head that can be life altering. And so again, this topic is really about protection of our girls. There were a couple of the players on the team that wanted to be here today, but they had class, and I was not going to accept them driving over and missing class. But are interested in this. Also, I'd point out that as a UW club sport, it's a little bit different even than recruiting as you might at the higher level. We do some recruiting, but we also take any girl that comes and wants to join the team. And so this bill would be hugely impactful for someone like me, would be in a very difficult spot if faced with that challenge of whether or not to allow a transgender student to be able to full tackle against the girls on our team. Also want to speak to both bills. I appreciate the definitions alignment. I think that's really important because we're running, so many of these different bills, and so I appreciate that work. Want to also speak on the bathroom bill as well. This was a need that we heard firsthand from a school district. We need the state to step up and give us guidance in the statutes on this topic, because our school board does not feel like we have the authority to do this. I will also say that I support the amendment as it relates to coaching. I think that's a really helpful provision. So with that, we'll keep it very short. Would stand for any questions and appreciate the work of the committee.
Thank you. Are there any questions for the superintendent? Seeing none, thank you.
Thank you.
I believe we have someone from the Department of Corrections who would also like to speak. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, for the opportunity to speak. My name is Heather Babbitt, and I'm the Deputy Director of the Department of Corrections, and I will just be brief today. We have reviewed this bill. We have no concerns with this bill. It is in line with our current policies and practices. We do not house male and female inmates together. We also do have men that work in our female facilities and women that work in our male facilities, but feel that this is accommodated for on page 7, lines 2 through 4. So again, we don't have any concerns implementing this statute, and it's in line with our current practices, and I would stand for any questions.
Thank you. Are there any questions?
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman, and thank you, Director, for being here today. How many, are there folks that you're currently housing that are identifying as transgender, and if so, how many of them are there?
Thank you for that question, Mr. Chairman, Representative Singh. We have a small number of, I would say maybe around 10 inmates that identify as transgender. Again, we house inmates based on male and female, but we do have a small number. And when we have an inmate that does identify as transgender, then we work with that inmate with a multidisciplinary team to address needs and issues. But again, we don't adjust housing based on that.
Follow up.
Thank you, Mr. Chairman, Director. To your knowledge, has there been any violence perpetuated towards those individuals?
Mr. Chairman and Representative Singh, not to my knowledge, sir.
Thank you. Any further questions?
Mr. Chairman, could I
Yes, go
just
ahead.
provide one small follow-up? We do follow the Prison Rape Elimination Act, which was passed in 2003, which was designed to protect inmates from sexual assault. And it does provide provisions around training, reporting, and we take that very seriously. So I just wanted to add that.
All right, thank you.
Thank you.
All right, we will move to public testimony. Given the amount of time we have left, I think we'll have about 25 minutes for those testifying both for and against the bill. Starting with against, we do have a significant amount of testimony online, as well as I believe in the room, so just please limit yourself as much as you can, just to be courteous to everyone else who would like to speak within that time.
This is against. I'm not sure.
And we'll be starting with against. Thank you.
Mr. Chairman,
Good afternoon.
thank you, Mike Smith with the University of Wyoming, neither for or against the bill, but I just want to address one provision in House Bill 60, please. Directing everyone's attention to page 6, subsection G, that's page 6, line 20 through page 7, line 2. Our athletic department has grave concerns about this language, Mr. Chairman. I've had many conversations with the bill sponsor, thank you for that, and other members of the committee. And as was stated, I think I understand the concerns around fairness and concerns around safety, but I think this language really doesn't address either, and in fact removes opportunities from women athletes, and oftentimes for no safety benefit or concern. We're very proud of our Cowgirls at the University of Wyoming. We recruit great athletes from all over the state, from the nation and the world, and we make them a promise, that we'll give them a chance to have an opportunity to compete, an opportunity that unfortunately many of their grandmothers and even some of their mothers weren't provided. They're not promised success, but they are promised that opportunity to compete and be the best they can be. And unfortunately, I read this provision as not protecting opportunities, but denying opportunities for our women athletes. And just real quick, a couple examples. We have a lot of sports, cross country, track and field, swimming and diving. They're team sports, but they're really based on individuals and how they compete on the clock, right? And so the way this provision is drafted, if we know or reasonably believe that there is a male athlete as defined in the bill competing on a women's swimming team, our swimmers would be prevented from competing in that meet. You're familiar with swimming. These athletes, they're trying to get a time to maybe compete for nationals that has a minimum qualifying time. Maybe they're trying for the Olympic trials. So they're really competing against that clock. And I hear the argument that there might be unfair competition. I understand that. Maybe they're competing in that case for the second place in that meet. But they're really, what's important is that opportunity to compete and to get that time to help them qualify. So I think that's really important. Same for our track and field athletes who are today, they're prepping for the Mountain West Conference Indoor Championships. That's an opportunity to qualify for NCAA championships. We have 40 athletes on our women's indoor team that go to these big open meets, and 28 of them will go to the Mountain West Conference event. And under this bill as drafted, one single athlete on one of the other 10 schools could disqualify our 28 women from competing at all. So we're just here to encourage you to reconsider and strike that provision that I've referenced. I think it's an unintended result and one easily repaired. I just close by saying I know you all want to support our women athletes. Thank you for that. A great way to do that would be to come over to Laramie or over the hill tomorrow, 2 p.m. Your Cowgirls are taking on CSU, so hope to see you there. You stick around for the 6 p.m. wrestling match and make a day of it. So thank you very much, and go Pokes. Thank you.
Thank you. Representative Kelly.
Thank you, Mr. Chairman. Just to clarify what we're talking about here, because this is a statute for the state of Wyoming, it will not affect teams outside of Wyoming. And then we have our ladies competing on the national level. You would like to leave it to the ladies themselves to choose if they would rather protest an event or compete against males rather than just make that decision for them. Is that correct?
Mr. Smith.
Mr. Chairman, Representative Kelly, I think that what I'm arguing for is certainly in those situations, those athletes would be consulted. But ultimately, that's a decision for the university administration, athletics administration, and board of trustees when faced with each individual situation to make that call. And I think that's where it's appropriately kept.
Further questions? Seeing none, thank you.
Thank you.
Mr. Winnie, are you speaking for or against this bill?
Mr. Chairman, Bill Winnie, Sublette County. I'm speaking for the bill. I'm speaking
Mr.
for-
Winnie, we're taking testimony against the bill first, and
Sorry, I didn't understand that.
that's all right. Thank you. Anyone else in the room speaking against the bill? Against?
Thank you, Mr. Chairman. Thank you, committee. My name is Sarah Burlingame. I'm the Executive Director of Wyoming Equality, and we are in opposition to both of these bills. And I just want to give a little bit of information that you may not already have on this bill today. Namely, as the good Representative Lawley said, that there was a lot of conversation about a lawsuit that would come when we passed the first bill. And that's absolutely accurate. We believed that we had a young athlete who would be the plaintiff in a case to challenge the legitimacy of this. But one of the things that we said over and over when we talked about this bill and the amount of time that we were leveraging to address it was that we had a total of 4 students in the state who we believed might qualify for that. And so when we looked to bring forward a lawsuit, that number dwindled by half. We had 2 students who actually had standing and could come forward and be a plaintiff in a lawsuit to say, we believe this challenges the constitutionality, our right to receive a free and fair education here in Wyoming. And so one family was not prepared to go forward with that. The other one's was. And as they prepared to move forward and become a plaintiff in this, the student was unfortunately harassed and made to feel so profoundly uncomfortable in her school that a guidance counselor said, there is an opportunity for you to graduate early. And you can get out of this situation that is doing such significant emotional harm to you. But in order to graduate early, you can't play sports. And so we have always said, we don't need more martyrs in the LGBTQ movement. We don't need more martyrs in Wyoming. We need healthy, happy, thriving individuals, whatever sex they were assigned at birth. We want them to be healthy and happy, graduate from school and go on and do whatever is fulfilling to them. Ranching, welding, disco dancing, we don't care, right? We just want happy, healthy kids. And so we, of course, said there is absolutely no pressure to come forward and be a plaintiff in this. If you are going to stop doing a sport that they loved and excelled in and were accepted by the other girls, because this will allow you to graduate early, we stand behind you, absolutely. So there is a sort of a catch-22 built into that if we had more students that this actually impacted, we think that we would bring a good court case and we would have the opportunity to sort of test some of these ideas. We think that we're unique among state LGBTQ orgs in consistently saying, we are not asking for no compromise. We are not asking for any transgender student to be able to play any sport despite the fact that they might have an advantage that can only be accounted for by the sex that they were assigned at birth. So we stand in opposition to both of these bills because we think they do a significant amount of harm. I would ask, and I'm sorry that I don't have the page number that you guys are looking at, but when the language that we use to talk about congenital anomaly, I think you're trying to capture intersex students in that to say, hey, if this is true of you, we're not talking about you. We're only talking about people who make a very intentional transition from one sex to the other. And so a piece of information that I would just bring is when we were researching these bills in the last 2 years that they were brought forward is the average age that someone knows that they're intersex is 21. So the idea that all intersex, babies are identified at birth or at puberty or someplace is just not accurate. And that when we think about how many people this might apply to, a good number to keep in mind is the low end is 0.8, the high end is 1.8 of our population are some kind of intersex, which means there's some sort of ambiguity in their sex or biology. A great way to remember how many people that would account for in Wyoming is it just happens to be about the exact same number of people in Wyoming who make their living solely through agriculture. So that's about 10,000 people. So if you know a rancher, if you know someone who makes their living solely through agriculture, that's about how many intersex people you probably know. Those numbers match up kind of easily. So we would just ask that you look more carefully at that language and say, if there is a way to make clear that they are not obligated to prove that intersex in any sort of exam or anything like that, that would be a kindness that you could do that would maybe strip back some of what we see as the unintended but cruel consequences of this bill. And so we stand in opposition, happy to take any questions and work towards any compromises that could get the most kids able to play sports and find a way to work alongside their peers here in Wyoming.
Thank you, Representative Kelly.
Thank you, Mr. Chairman. I concur. I don't wish to malign or ostracize any human being in this process. But I do have a specific question about, we were talking about intersex individuals, and you had mentioned that many of them, the typical age they find out is 21. Now, if the individual doesn't know, how would the rest of us know?
Thank you, Representative Kelly. Thank you, Mr. Chairman. Representative Kelly, there's a variety of ways that could come about that are not speculation. A lot of them are speculation, but I'll just stick to the ones that we've seen here in Wyoming. We had an incident in Casper. Can I say Casper? I can say Casper, right? We had an incident. We had an incident in Casper where the student actually was not intersex and the student was not transgender, but because they had some characteristics, and I would say as an outside observer, the characteristics seemed to be she was really good at sports. Like, I would not, that was it, right? Like, I don't think her shoulders were set any wider than mine or that she had any other sort of secondary characteristics, but she happened to be really good at sports. And so a member of the community in a position of authority asked, like, we would like to see something that proves the gender of this child. So on the extreme end, I think we have that. I think we have people who have bad will or just will be using random children to test, to ask, will you prove your gender to me? I don't think you need to be a mother of a daughter to understand how harshly you would resist that and not allow anyone near your daughter who wanted to do that. And then on the other end, I think you have people who genuinely do have some ambiguity that is evident. Another example, we had a kiddo who she just didn't get her period when everybody else did. And so that led to a trip to the endocrinologist. And biologically, this young woman, who you would never in a million years conceive of as being anything other than a young woman, has on her medical record, and those medical records can be shared with the schools, she's biologically considered male. I mean, it's a very specific syndrome, right? And I do think that you are attempting to address that by saying this is a congenital issue. But when you ask for how would this even come about, I think those are two ways. One, I think, is a sincere way that nobody had any bad intentions on. And the other one is the one we've seen in Utah used much more vociferously than in Wyoming. But I think when bills like this pass, we'll see it. Just people being cruel and picking on kids and asking them to prove their genitalia to interested and curious adults. What a nightmare.
All right, thank you.
Thank you for the question, Representative.
Thank you. Maybe one more quick question. I think we should probably get to other people, but Representative Bratton.
Thank you, Mr. Chairman. So you mentioned those statistics. Tell me about, where did you get that data?
It's a great question. Mr. Chairman, Representative Bratton, 1 second here. I will pull it up because we sourced it, which I'm real proud of ourselves for doing. Sources. I can share this with you as well, but it looks like that one came. Is that the APA? I don't know. I can tell you we looked up the USDA website to find the number of, for agriculture, but the other number about intersex, I think it's
Would you be able to get it to us after the
I
meeting?
absolutely will. I apologize. And I will
Thank you.
try really hard to be so brief.
Thank you. All right, seeing no one sitting at the desk, could we bring an online testimony?
Thank you, Mr. Chair.
Yep, Mr. Chairman, we have Nyoka Erickson. I believe they're ready. I apologize for my pronunciation if that was a bit off.
No worries. Thank you,
Right.
Mr. Chairman. Thank you, Mr. Chairman. My name is Nyoka Erickson, and I'm from Laramie. I'm from your district, in fact. And I'm here to speak in opposition to the bill, to House Bill 60, because I've played sports for most of my life. I played hockey on both the boys' team and eventually a girls' team when I was a kid. I played a couple of years on the UW women's hockey team, and I currently play women's flat track roller derby. And I think that it's extremely inappropriate for the state to be taking away an opportunity through the provision that I believe there has already been some testimony on prohibiting competition against teams. I think that just takes away opportunities from women. I would have been really upset if I hadn't been able to be a part of that decision as a member of a college team. If somebody had told me, an adult, like, this is what you're going to do, this is what you can do, and we're not letting you do this. So I'm concerned about that. And I also think it's inappropriate for the state to tell sporting organizations what their policy should be. So for example, I play roller derby. I play under the Women's Flat Track Roller Derby Association, and under their rules, trans women have played roller derby, a contact sport on roller skates, for about 10 years now with no restrictions. And that's a decision that WFDA and the member teams, the member leagues of the organization got to make for themselves. And again, I'm happy I've played many games against teams that had trans women on them. I've played many games against teams that were all cis women. I'm worried. I don't think it's your intent with this bill to limit women's opportunities for sport. And I'm worried that especially with the provision that prohibits competition, that you are inadvertently taking away opportunities. Thank you. Thank you, Mr. Chairman.
Thank you. Are there any questions? Seeing none, I believe we have one more online.
Yes, Mr. Chairman, JD Dolinar, and then there was an additional person who raised their hand, James Worthen. So whenever you would like to, you have one more after this as well.
All right, thank you. Please go ahead. We have 7 minutes left.
Whenever you're ready, JD, you can turn on your camera and your microphone.
Oh, I'm sorry. I had my microphone off.
No worries.
Okay, sorry about that. Good afternoon, Mr. Chairman and members of the Education Committee. My name is JD Dolinar. I am a lifelong resident of Southwest Wyoming, higher ed educator, and STEM doctoral candidate in environmental archaeology. I'm here to share my perspective as someone born with a congenital genetic malformation, which refers to being intersex, a medical condition. During my time in middle school and high school here in Southwest Wyoming, I often felt out of place due to living with Klinefelter syndrome, especially in locker rooms where changing in front of peers was required. To find privacy, I started using bathroom stalls, which unfortunately made me a target for harassment. Seeking safety, I began using restrooms outside of the gym. When school staff noticed, I explained my discomfort and the bullying I faced, but instead of receiving support, my concerns were dismissed and I was assigned punishment. I share my experience to highlight the harm caused by misunderstanding the complexities of biological sex. HB 72, in my opinion, perpetuates this reductivity, denying intersex and transgender individuals basic dignity and respect. Biology is not simple. The Health and Human Services Department estimates around 1.7% of humans are intersex, though many go undiagnosed. I myself was not diagnosed until my late 20s. Thus, the issue is far more nuanced than the bill conveys. HB 72 therefore risks harming vulnerable students and should be modified or rejected in favor of policies that uphold privacy, dignity, and respect for all. Thank you, Mr. Chairman and members of the Education Committee, for hearing my testimony.
Thank you. Are there any questions? Seeing none, thank you.
Mr. Chairman, it looks like James Worthen is ready to go.
Good afternoon. Please go ahead.
Thank you, Mr. Chairman, members of the committee. My name is James Worthen. I am a resident of Casper, Wyoming, and I've been a member of the Wyoming State Bar for more than 20 years. I'm a practicing attorney, and during the last 20 years, it has been my great pleasure to represent a number of school districts in the state of Wyoming, as well as some of our higher educational institutions. Today, my comments are primarily directed at House Bill 72 and my concerns. While I will leave the substance of the ethical questions of the appropriateness of this bill to some of the other speakers, what I really do want to focus on for the committee's attention is the potential damaging effects that this bill could have for our school districts and for our institutions of higher learning as it relates to the enforcement and or civil liability of this bill. And what I mean by that, and I'm focusing specifically to the proposed changes to Statute 925-103 subsection H. As the committee is aware, there's no enforcement mechanisms defined whereby the school districts or the institutions of higher learning are given guideline or direction on how to enforce this bill other than to take reasonable steps. As a practicing attorney for more than 20 years, I can guarantee you that definition changes drastically between parties. One individual's view of what is reasonable drastically changes from another. And the problem with this bill as defined, or the lack of definition in the enforcement, means a couple of things. First, it is unlikely that either our school districts or our higher education institutions will be able to have this be insurable, which means that this money, if a civil action is brought and enforcement brought forward, this money would have to come out of the general operating account, both legal fees as well as any fines or penalties. This could have a detrimental effect. Second, it also is one in which, given the the quote unquote reasonable steps provision, this also leads to potential enforcement abuse. Whereas if you fail to abuse or you fail to enforce, you're subject to liability. But if you over enforce or you take unreasonable steps to ensure, there is no liability. So by that definition, school districts or higher education institutions may over enforce or take unreasonable or more draconian steps towards enforcement. And that may lead to some of the devastating impacts that some of the other panelists have talked to you about. Ultimately, what I'm concerned about here is not the question of whether or not we try to protect women or men in our schools. What I'm concerned about is that anytime you open up public institutions as well as their employees to potential civil litigation and violations, we are at direct risk of putting those institutions in financial jeopardy. We are at direct risk of placing those employees at financial jeopardy. And because of that, and given the ambiguity or lack of enforcement mechanisms as put forward in this statute, there is a real risk of significant damage to the effectiveness of our educational institutions. And so again, I don't wish to debate the merits of whether the bill on its the idea of is good or bad. I simply want the committee to understand that in the enforcement of this bill, were it to become law, that we could be in a situation where schools would have to go to government to ask to raise property taxes because they're being subject to these kind of fines or penalties because somebody viewed what they did or didn't do as unreasonable. Thank you, Mr. Chairman.
All right, thank you. 10 seconds for a quick question, anyone? All right, seeing none, thank you. All right, we will now move on to those in the room speaking in support of the bill. Please take a chair if they are available. And we have a significant amount, maybe 10 people online, as well as I see a lot of people in the room. So please be mindful of that when you're giving your testimony. Thank you. Good afternoon. Please go ahead.
Thank you, Chairman. My name is Dr. Rich Guggenheim. I am the Director of Legislation for an organization called Gays Against Groomers. I am here today to ask for a yes vote on HB 60 as well as HB 72. I want to briefly make 2 points of clarification. These bills would not apply to organizations like WWFDA. Second, intersex is a term used to refer to rare medical conditions that still fall within the sex binary and are not a new gender identity or expression. We should use caution and be respectful when using people living with a medical condition to advance a political agenda. I've had the privilege of traveling across the nation speaking on this issue with people like Riley Gaines and Jen Say. In Colorado, I was a proponent of Initiative 160, Protect Girls Sports, which is nearly identical to HB 60. In fact, I find it ironic that they both end in 60. Let me begin by addressing HB 72 by reading our statement on the bathroom issue. Quote, we understand that there is an ongoing discussion regarding trans adults which use spaces that are more appropriate for them. There are nuances to consider when it comes to adults in public spaces, like needing to use an empty male restroom as a pregnant female because the need is too strong to think about any potential dangers. If you've ever been a pregnant woman, you understand that. Many passing trans adults have used the restroom they externally identify with in peace without confrontation. There are risks present for using any public space. Predators exist in every scenario, and children should be supervised and safeguarded while they're in their most vulnerable state. Several countries have had gender-neutral bathrooms for some time. When it comes to trans adults, gender-neutral single stalls are usually available and preferable when possible. We believe public spaces like schools should maintain the binary bathroom model to reduce possible harm to minors and provide separate single stalls for safety. We have heard stories, in fact, on the other side of the aisle today in the Senate on a bathroom bill where we shared a story about females who were exposed to a man in school doing inappropriate things. But on the other side of that, there are often boys who are being accused by their female counterparts of doing something that never happened. This helps protect children in both scenarios. Now moving on to girls' sports. It's providing them with privacy and safety in the restrooms. And the girls' sports issue is not a right versus left issue. It is a right versus wrong issue. A recent New York Times poll asked the following question. Thinking about transgender female athletes, meaning athletes who are male at birth, but who currently identify as female, do you think they should or should not be allowed to compete in women's sports? 79% of Americans said they do not believe men belong in women's sports. This includes 67% of Democrats and 94% of Republicans. Americans have spoken, and the reality is that until politicians from across the political spectrum are willing to stand up and speak up to protect sex-based rights, sex-based discrimination is going to continue to happen under the guise of inclusivity and equality. My question is this: what are we going to make this happen? Why do we hear some people, even after hearing the polling and data and testimonies of female athletes and women today, vote no on common sense legislation? How do we hit the campaign trail and say we're going to protect women's rights, then come back here to this building and vote no, look at women in the eye and vote no on bills that protect their rights? It's unconscionable to me. We've heard some people say that the SCOTUS-Bostock ruling includes protections from discrimination against gender identity and expression. This ruling only extends protections to employment and didn't even define what transgender identity meant. Women have fought for, and they deserve the right to keep a safe, fair place to compete and their privacy. When it comes to trans rights, women are being told to be kind and compassionate and put the rights of men who approximate them, appropriate their rights, and colonize their spaces above their own. This type of emotional manipulation is a form of abuse. It is blatant sexism, and it is bullying. The proper role of government is to protect the freedom and liberty of its citizens, including women. And this bill, both of them, do just that. That's why I'm asking you to vote yes on HB 60 and HB 72 to protect female rights, just as Title IX and women's rights require. Thank you.
Thank you. Are there any questions? Seeing none, Ashley, can we go to Miss Earhart online? She has a scheduling conflict, but has some testimony that Representative Lawley would like to hear on her bill. And then we'll go back to the room. Thank you. Please go ahead.
Thank you. Mr. Chairman, can you hear me?
We can hear you.
Oh, fantastic. Mr. Chairman, Representative Lawley, and good committee, I am Idaho State Representative Barbara Ehart. I'm so happy to be here. I was the first person to bring this legislation forward. I testified in many of the states, both personally and via Zoom, that has brought this legislation. And so that's often just that alone is impressive to people, but what people really want from my testimony and what I think I can help provide to this good committee. And so thankful that Wyoming, with your rugged background and knowing the difference between men and women, has decided to take this up. What the uniqueness of my testimony is, I was a Division I athlete, played basketball, but I spent 15 years coaching Division I women's basketball. And I'd like to share a little bit of common sense logic that I think that we can use and other states has used to kind of piece some of this together. You see, Title IX actually did change my life. It provided me with that opportunity to play collegiately on a scholarship. And then, as I said, to then have a 15-year coaching career at UC Santa Barbara, BYU. I say BYU because we played Wyoming. We made that trip up there multiple times. That was tough. Then also at Washington State, and then as the head coach at Cal State Fullerton. But I want to talk about a couple of things that I think that will really resonate. So many times as I've gone through this process, the other side likes to say, though I didn't hear it today, but they say that it's important that we allow men to compete in women's sports because it's about the humanity and the inclusivity, and it's about community, and that those are supposedly so important that that's why we need to have them in our spaces. But you see, those may be subsets farther down. Ultimately, when it comes to competition, it is about winning. And this point is important. It's about winning, because if it wasn't about winning, coaches wouldn't get fired and players wouldn't get cut. So let me tell you now, let me tie this in. Names you may or may not know. I know everyone here is familiar with the name of Lia Thomas, but what people probably don't know is in 2020, just before COVID shutdown, in Montana, our Idaho State women, and no doubt your women, had to compete against June Eastwood. June Eastwood had run for 3 years at the University of Montana as John Eastwood, and then decided to run the last year as June Eastwood. Well, June parsed out June's win throughout the season, and in 2020, in the indoor Big Sky Championships, June went up against all of our young women in the 1600, formerly known as the mile, and annihilated these women, annihilated. Had we not been shut down for COVID, June would have been the first Division I champion of a man taking a women's championship. And now I say this because in the college level, we are a peat and repeat. And this is incredibly important since you all have been so good to take it up at the university level. If June CC Telford did the same thing, CC Telford's senior year was a man then identified as a woman, won national championship, and Lia Thomas had decided their freshman year to compete as women. rather than their senior year, I am telling you that in order to keep their jobs, every person in the Big Sky, every person in the Ivy League, and every school against whom they'd be playing would be forced, in order to keep their job, they would have been forced to go out and find someone to counter what those men offered. It's how it is, because it's about winning. And I kid you not, coaches lose their job even when they're winning if they're not winning big. And that's why it's so important that we realize this. Title IX, pre-Title IX, 1 in 27 gals participated in high school. Post-Title IX, now we have 2 in 5. That's almost 1,000% increased in high school, and it is an increase of over 540% at the collegiate level. We have provided opportunities for women that has absolutely changed their lives. We have 23 states, 25 that have signed this legislation, including you guys, but adding higher ed means you would be joining the rest of us in protecting our women at all levels, which I think is incredibly, incredibly important. There are a lot of things that I think I would like to answer. I know there had been a concern brought up about the processes. I mean, as far as would women unfortunately be forced to go through inspections? Folks, there are already processes in place that are handled by athletic directors.
Representative Ehart.
Yes, you are right, sir. I believe we're about at 5 minutes, and I thank you for listening to me. Very much appreciated.
Thank you. Any questions? All right, thank you. Ms. McCoy?
Good morning, Chairman, or good afternoon, Chairman, and members of the committee. I forgot what time of day it was. I've been here all day with you guys. I am Patricia McCoy. I'm the chapter chair of Moms for Liberty, Laramie County. I'm also a mother to 3 boys and 1 daughter. I am here to speak in favor of both bills for very good reason. As a mother, it is my duty to protect my children, to look out for their safety and well-being, and guide them as they go through life. Now, as a mother and a woman, I'm being told that I and my daughter must give up our rights to privacy and safety in public spaces such as restrooms, changing rooms, lockers when we go to the gym, and private areas and spaces such as a bar. My daughter just turned 21 on Wednesday this week, and she spent the first half of her birthday in this very building, hoping that she would be able to testify on Senate File 62 before the Senate Education Committee, which is similar but also different. She, like her mother, great-grandmother, and great-great-grandmother, is very passionate when it comes to fighting for the protection of women and girls in their designated areas, and she was upset she could not be here to speak before you today since she had to work. How am I, as her mother, to protect her and tell her she is safe when it is made clear that she is not? How am I to expect and encourage her to forget what her great-great-grandmother and her great-grandmother, along with many other women, fought so hard for? They came before us and fought for our right to vote. They fought for our right to buy a home and have a credit card without our husband's permission. They fought for many years to get us the Title IX protections that are still in place today. If we want to protect our women, we must stick to the Title IX rules as they are originally laid out and written. I'm not here to say that all trans people are the enemy of women. I am also not saying that they do not need appropriate accommodation. However, we have several examples in many states across the country which show us what happens when we allow men who claim to identify as women are allowed to enter the private spaces of women. We're seeing instances of women being attacked in bathrooms, locker rooms, and even our prisons. And when those women speak up or speak out against it, they're told that they are the problem, they are bigots, and other hurtful attacks on their character. They are none of those things. They are women fighting for their rights and being told to be quiet and just go along. What I am here to say, and will end with, is that as the equality state, the first state to fight for and defend women's rights, it is our duty to continue to do as such and to protect our women and girls in their private spaces as already fought for and laid out under the Title IX guidelines. And I'll take any questions, please.
Thank you. Any questions? Seeing none, can we please go to Macy Boggs online, then we'll come back to Mr. Whitty.
Hello. My name is Macy Boggs, and this year marked my final season with the University of Wyoming women's volleyball team. I am here today in support of the HB 60. a bill that ensures fairness for women and girls in sports. Women and girls deserve access to fair competition without the threat of male athletes taking their spots. During my final season, my team unjustly received 2 losses for refusing to compete against an opposing women's team with a male athlete. This injustice ultimately kept us from the Mountain West Conference tournament and denied me the chance to play my final collegiate matches. No woman should ever be forced to choose between competing against a male athlete, robbing us of fair and safe competition, or forfeiting the rest of her season. The emotional toll on my teammates and me was enormous. We spent countless times in meetings and discussions, fostering anxiety, fear, and tension among not only ourselves, but also our administrators, which this ultimately harmed team and morale focus. The burden of defending our rights fell on the shoulders of 18 to 22-year-old young women who simply wanted to focus on playing volleyball, not battling conference leaders or NCAA policymakers. This provision outlining clear guidelines for how a Wyoming school must handle competition against a team with a male athlete would have spared us from that distress. It's a necessary step to ensure that the responsibility does not lie upon the girls and young women to defend themselves. With this provision, leaders in Wyoming are ensuring other Wyoming women's teams will not face the same emotional turmoil and public scrutiny that ours did just to receive the most basic standard of sport, fair and safe competition. Women work hard to improve and to compete at the highest level. We deserve to face athletes whose body aligns with our own, not a male standard. For that reason, I am now suing the Mountain West Conference alongside 11 women from 5 universities to protect the next generation of female athletes. I stand firmly in defense of women's sports because I believe in the truth. Men have inherent physical advantages in women's sports, regardless of their identity or medical interventions. Sex is determined by biology, not feelings or identities. It is time for policymakers to take a stand and preserve women's sports as a space where girls can compete with fairness, integrity, and safety. Not another woman in Wyoming should have her athletic career cut short because a male athlete took away her earned opportunities. While it may be too late for me to finish my career at Wyoming on the terms my team earned, it's not too late for the girls coming up behind me. I implore you to vote yes today to ensure a fair and just future for female athletics. Thank you.
Representative Singh.
Thank you, Mr. Chairman. Ms. Boggs, thank you for taking some time to talk with us today. I do have a question about how it is truly unfair that your team was not able to compete because of the circumstances surrounding the competition. If your team were able to have taken some sort of vote, would your team have chosen to compete with any of the other teams that you weren't able to?
Yes, so we did have a meeting with our administration where we were able to place anonymous votes. However, the results of that voting came out equal.
Representative Lawley.
Thank you, Mr. Chairman. Macy, I just want to say how much I appreciate you coming today and supporting this bill, and just for your courage and stepping out and trying to make a difference and moving on beyond just what happened here and working with other girls around the country. Thank you so much.
Representative Kelly.
Thank you, Mr. Chairman. I just wanted to clarify one point you were saying here. You were saying that men have inherent advantages despite having medical intervention. So if I'm hearing this correctly, I'm a 6'9" man, that if I artificially suppress my testosterone levels, I'm still 6'9"?
That is correct.
Thank you.
Yeah, every cell in your body bears witness to your God-given and born identity, and you cannot change your XY chromosome.
All right, thank you. Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. I support both bills. Along my 30 years career in the active duty in the Navy, I served as commanding officer of the USS Holland, a crew of 1,300 to 1,400, of which about 350 were women. The rules the Navy has for berthing spaces, sanitary spaces, and so on for women require hard, rigid bulkheads surrounding those quarters. They had to go back and figure out how to redesign ships in the future for that, but that worked out not that much of a problem. But it's also known that women in damage control situations, for instance, firefighting, the Navy uses an oxygen breathing apparatus. It's not a pressurized cylinder, it's an organic cartridge, and it produces oxygen by your respiration rate of moisture. And it is known that women's uptake of oxygen is lower than men. And we have to factor that in when we send people or women into a compartment with a fire. So in essence, we know full well that women our musculature and skeletal are different than men, and they are lesser than men. And that is a fundamental issue you are dealing with in sports. Subject to your questions, thank you.
Thank you. Any questions? Seeing none, could we go online to Jay Curtis, and then we'll come back to Mr. Winters.
Good afternoon, Mr. Chairman, members of the committee. My name is Jay Curtis, Superintendent Park County School District number 1 up in Powell. And I would like to start by saying that I am in support of House Bill 72. I'm speaking on behalf of our administration and Board of Education here, who passed a resolution this past November seeking legislation to help clarify this issue for Wyoming school districts. A little bit of context. For about the last 8 years, we've been operating under what is called restroom of choice. And the reason that we've been operating under restroom of choice is that court cases settled around the country in the 7th Circuit, 4th Circuit, 11th Circuit were all trending in favor of transgender rights in this issue. Recently, the 11th Circuit reversed itself on a school board who had passed a policy from several years ago. And so we desire to look at a policy in our district, and according to our attorney, it's just not safe for us to do that. And individual school districts should not have to strike out on their own. It's not wise for us. It's not a wise use of public funds in our district. That is, those funds are designed to support student learning. And so we, feeling that we were up against a wall, we did start seeking the help of our local legislators, but then I also became aware of Representative Lawley's bill that she's been working diligently on since August. So just want to lend support. I will say one thing, that I think it is hard to ignore and potentially disagree with the attorney from Casper who testified earlier, who had some really good points with regards to the civil action. As a general rule, I typically don't support any additional civil action against school districts that doesn't already exist, because they do. So on and for this bill, but I would ask that you please examine the unintended consequences of any potential civil action against districts as a result of this. I would stand for questions.
Thank you. Are there any questions? Seeing none, Mr. Winters, we have about 2.5 minutes left.
Thank you, Mr. Chairman. Committee, my name is Nathan Winters, President of the Wyoming Family Alliance. I'll go very quickly. I just want to express this on behalf of the thousands of folk who we interact with at Wyoming Family Alliance. These two issues are some of the largest that we hear about across our state. And it's clear that over the past half decade, biology and ideology have clashed in ways that I believe caught most of the country by surprise. And that is abundantly clear in the issue of sports. And it's for this reason, the simple picture of fairness in women's sports is something that almost everyone recognizes as needing to be fixed. But also addressing Representative Lawley's women's privacy in public spaces. I want to just demonstrate, oftentimes in this capacity now, I used to sit over there, now I sit over here. I now have the chance to look at legislation on both sides of this building. And what I can see is that this is very, very carefully written to take care of a number of issues. And I believe that both of these bills need to be passed. And I believe that the vast majority of the state of Wyoming are looking forward to the vote you're about to cast. Thank you.
Thank you. I think we'll just go straight online to Miss Lundgren, as we are running out of time. Thank you, Mr. Winters.
She's joining the room now, Mr. Chairman.
All right, thank you.
Thank you. Can you hear me?
Yes, you have 1 minute.
All right. Thank you, Mr. Chairman. My name is Sarah Lundgren. I'm a mother of 3 children. I'm also a school board member. Obviously, I can't speak on behalf of the school board member, but I very much reiterate what Mr. Curtis had to say and would like to say that I actually pulled my daughter from school when a boy started using her facilities that was in her same grade. And it is vitally important that we protect our children, that we teach our children that there's only 2 sexes, like the federal administration is doing now. But I think this bill is so important because no matter what federal administration comes next, Wyoming would be protected. And so I am so proud of Representative Lawley for standing up and putting this bill forward. And I think it's so important. I also believe that our children get told many times in our school districts that there are other truths. And this saying that there is male and female helps stop some of that narrative. It is extremely important for our children, not only
All right, thank you for your
children,
testimony.
but all.
Sorry,
Thank
cut
you.
off. Thank you. All right.
Wow.
Public testimony is now closed, and House Bill 60 is back on the table for our consideration. Committee, what is your pleasure? Moved by Representative Strzok, seconded by Representative Guggenmoss. Are there any amendments? Oh, Representative Kelly.
Yes, thank you, Mr. Chairman. In regards to the concerns brought by UW, page 6, lines 20 through 22, continuing on to page 7, lines 1 and 2, that section there that prohibits teams from playing against a team that they know may have a male on it, it does appear relatively restrictive to me. We're not talking about children, college athletes. These are young women. They're not children. They can decide for themselves. And the volleyball team did make the correct choice and refused to compete against a team that was competing unfairly. So I would like to strike that portion of it because we cannot control what other states are doing. And we would be limiting what some of the women competitors could do if we left that in there. Oh, I would like to make one last.
Does this amendment have a second? Sorry.
Oh, I'm sorry.
Representative Guggenmoss, seconded it.
Thank you. Yeah, I'm still new here.
That's my fault.
Also, I'd like to add in that Mike Smith from UW wanted to make clear he didn't have a chance before and he had to run out to another meeting, that the university would not penalize any woman who refused to play if the team decided to play.
Representative Singh.
Thank you, Mr. Chairman. And Representative Kelly, I have kind of prepared a little bit of language, and I'd like to see if you'd be amicable to amending your amendment to that. So after the male sex on line 2 of page 7, replace the period with a comma and insert the word unless, and then create new paragraphs afterwards. So 1 would say the members of the team designated for female students vote to permit such participation by a supermajority of at least 2/3 of the team's active roster. Then the next paragraph would read, the vote is conducted anonymously with oversight by the school's athletic director or a designated official to ensure fairness and compliance with this section. A third paragraph saying no member of the team is compelled to participate in the athletic activity against their will as a result of the vote. And fourth paragraph saying that the school publicly acknowledges prior to the event that the team has elected to compete with or against a team that includes a biological male. Such acknowledgement must be communicated in writing with the opposing team and made available to parents, guardians, and to the broader school community no less than 72 hours before the athletic activity. The acknowledgement must include a summary of the decision process and affirm that the decision was made by a supermajority vote of the team.
Representative Lawley.
Thank you, Mr. Chairman.
One thing real quick, does the second and the sponsor agree to that amendment?
Did you just think of all that right now? I would agree to that, but I would like to see some language that also protected the right of the individual to compete in individual events too. So yes, I'm good with that.
Representative Lawley.
Thank you, Mr. Chairman. I would advise against voting for this amendment. First of all, it's pretty extensive to be doing on the fly like this, and there are some unintended consequences. What I would suggest to you, and I was already planning to do, and I have already started some discussions with Mr. Smith concerning how we could amend this language. And so I was planning to bring an amendment already for Committee of the Whole myself. So because there are nuances here that I think doing this on the fly is a little bit troublesome for me.
Representative Kelly.
I withdraw the amendment in light of that new information.
Thank you. Is there any further amendments? Seeing none, is there any discussion? Representative Williams.
As a co-sponsor of both of these bills, I've always been in support of legislation that protects women's privacy and fairness in women's sports. And in the past, I've reviewed other bill drafts on these very issues, but I'd just like to point out how much more complete this legislation is than anything I've ever been involved in the past. And during this process, I've found the very best way for me to help Representative Lawley is to just stay out of her way. And so, Mr. Chairman, I'd just like to thank Representative Lawley for all of her hard work in bringing this legislation.
Thank you. Further discussion? Representative Strzok.
I was just somewhat, oh, thank you, Chairman, sorry. Would agree with Representative Williams. What we're doing, trying to hear, this will weaken the bill, and we need to keep this a very strong bill and draw a line in the sand somewhere, and just let Representative Lawley work on this, add some things. So I'll be an eye on both of these bills, so thank you.
That having been said, please call the roll.
Mr. Chairman, on House Bill 60, student eligibility in sports amendments do pass. Representative Bratton?
Aye.
Representative Erickson?
Aye.
Representative Guggenmoss?
Aye.
Representative Kelly?
Aye.
Representative Lawley?
Aye.
Representative Singh?
Aye.
Representative Strzok?
Aye.
Representative Williams?
Aye.
Chairman Andrew?
Aye.
That is 9 ayes.
Thank you. The bill has passed the committee. House Bill 72 is now back on the table for our consideration. Committee, what is your pleasure?
Move the bill.
Moved by Representative Strzok, seconded by Representative Guggenmoss. Are there any amendments? Representative Lawley.
Mr. Chairman, I would like the amendment that I have passed out to the committee and referred to earlier, and which our secretary has. And here's what it does. On page 11, after line 18, insert and renumber, is Romanet number 3, a school official or employee who enters the changing area, restroom, or sleeping quarters while in performance of the official's or employee's official duties and who takes reasonable steps to ensure that no person in the room is in a state of undress. And then it continues on already in the bill.
Thank you. Do we have a second on the amendment?
I second it.
Seconded by Representative Strzok. All those in favor, any discussion? All those in favor say aye.
Aye.
Amendment passes. Any further amendments? Discussion on the bill.
Question.
Please call the roll.
Mr. Chairman, on House Bill 72, sorry, I had the wrong one. House Bill 72, Protecting Women's Privacy in Public Spaces Act, do pass. Representative Bratton?
Aye.
Representative Erickson?
Aye.
Representative Guggenmoss?
Aye.
Representative Kelly?
Aye.
Representative Lawley?
Aye.
Representative Singh,
Aye.
Representative Strock,
Aye.
Representative Williams,
Aye.
Chairman Andrew. That is 9 ayes.
The bill passes the committee. We are now adjourned. Thank you.